My name is Michael Young, and I'm a lawyer who handles life insurance beneficiary disputes. Let's talk about a situation in which a former spouse is the designated beneficiary of the life insurance policy. Can a former spouse recover life insurance proceeds? Well, the answer is it depends on the specific situation, which is why it's extremely important that you consult a lawyer who is experienced in handling these life insurance dispute cases. The first question that you have to ask is the policy governed by federal law? If it is, then yes, typically the former spouse, if they are designated the beneficiary, typically can still receive the benefits. And the situations such as when someone obtains a policy through an employer, ERISA will apply, or if they're a federal government employee, or if they're in the military service, or they obtain veterans group life insurance benefits. In those situations, typically the ex-spouse can recover, and there may be some limited exceptions that you'll need to review with a lawyer. But how about a situation where state law controls? And in this case, Texas law. If there's a policy in which Texas law governs, an ex-spouse may be disqualified from receiving the benefits. So let's talk about a common situation. Husband and wife are married. Husband owns a life insurance policy. Then he gets divorced from the wife. He forgets to change the beneficiary, or for whatever reason he does not change the beneficiary, then he dies. Does the wife get to collect in that situation the life insurance proceeds? Well, the Texas Family Code deals with this situation. It's section 9.301 of the Texas Family Code, and it says that designations in favor of former spouses in life insurance policies are invalidated unless certain conditions are met. The first exception is when the divorce decree designates the former spouse as the beneficiary. If the decree specifically says that the husband will maintain the former spouse of the policy and specifically details the policy. The next exception is if the insured redesignates his former spouse as the beneficiary after the divorce. Another exception is when the former spouse is designated to receive the life insurance proceeds in trust on behalf of a minor child that the couple had before the divorce. If those exceptions do not apply, then the former spouse is treated as if he or she predeceased the insured. The insurance company still has to pay the money, but they're not paying it to the former spouse. Instead, the insurance company will pay the money to the contingent beneficiary. If there's no contingent beneficiary listed, then the insurance company will pay the money to the estate of the insured. Once again, it's extremely important that you consult a lawyer who is experienced in evaluating these cases.